of course, so many sessions, and obviously it's always a pleasure listening to you and your insights. Very valuable. So thank you. That's all.
My absolute pleasure. It's a real honor, and I love it every time that we connect up, and I love where the conversation goes. So thank you again for the work you do in bringing the mediation world together.
Okay, I think that's the good part about the conversation. It has gone in various places, and all of those directions have been really, I mean, I think that those are things we need to explore, of course, further. But I think what you brought out has been really important. I think that mediators as leaders, that aspect needs to be explored a lot.
Yeah.
So basically, World Mediators Conference, theme being Mediation Vision 2026, Evolution of Mediators and Mediation. The idea is, of course, to get thoughts from everyone around the world, and then as we go through the year, we'll have more discussions, more elaborate discussions on whatever we feel are important areas. And started on 18th May with Ken Cloke's, of course, inaugural address, and of course, celebrating his birthday. So please watch them on YouTube. And what I can also do is, because we have those 30 seconds before the actual times, because I always, of course, your colleagues also, someone is here, Michael is here?
Mikhail, I think,
Mikhail, okay, so Mikhail is coming in. So I was, okay. I think I wanted to go through that sheet, the schedule, but the schedule is available. All details are available there. So.
Oh, Michael.
Hi, Michael.
Hello, how are you going?
Good. Is it Michael Me? Why the Michael Me?
Well, because they couldn't be bothered to do any more, but it's actually Michael Megan. It's MEEGAN, which from our Irish tradition is Michael the Honourable.
Okay. So how do you spell that? M-E?
MEEGAN and Michael Megan.
And Australia.
I'll
tell you why I put it there. I keep telling people why I put it there, because of the fact that there are stereotypes in this world about people from a certain country, and people should know that, look, Sarah comes from Australia. She's not the stereotype that you think of Australians. So Michael is not like that. So that's the idea. The idea is not to divide people into countries, actually bring that part out. So that's what it's
about. I completely understand. Nice to meet you.
Nice to meet you, Michael. And of course, what Sarah is saying, she has only about 15 minutes. I mean, of course, we would hope that she extends that as she goes along. And Sarah and me have had some very interesting discussions. So please go to my YouTube channel. You just go to YouTube and search Mediator Vikram and Sarah Blake. You'll find a lot of sessions. Really, really important discussions, according to me, because what she brings out and her work with the indigenous communities, I think really is going to help people around the world. So that's how fantastic. It is. So what we're going to do is, this is sustainability and mediation. So from here, Sarah is going to, of course, you can hear about Sarah from her mouth in other sessions. We won't waste her time on that. Just a 30-second introduction, and we'll take it from there. Sarah, please.
Thank you very much. Sarah Blake joining you all again today, mediator, conflict strategist. Why am I talking about sustainability and mediation? This issue, we were trying to work out how can we bring together some of the environmentalisms, new trends, what matters to people, and I guess we brought together this notion, broadly speaking, sustainability and mediation. This is an issue that's really close to my heart. I know it's close to Michael's heart, and Mikhail, who might be joining us today as well, are really interested in how do we use the mediation process, its model, in a way that is sustainable. And what does sustainability mean, in fact? And I know, Vikram, you're going to have more conversations around the Green Pledge and some of those environmental issues, but we just thought we'd set the scene in a way around what does sustainability and mediation mean. So I've done a lot of this work, particularly around multi-party cases, working with communities, working with government and companies. But I've asked Michael to be here, one, because I can't be here all the time, but Michael brings a great wealth of experience around working on the ground with people, helping negotiate agreements, working with Indigenous people in Australia, but also understanding those complex dynamics of what it takes to help people reach an agreement itself that is sustainable. Michael, do you want to give a quick spiel, an intro of yourself as well?
Yeah, I think the quick spiel in relation to that space is really since 2004, since I was working in native title. And then from 2007 onwards, coming up as the principal legal officer at the Yamatji Marlborough Aboriginal Corporation, which covers about 1 million square kilometres in Western Australia, we were thrown into the mining boom and we were negotiating all sorts of agreements with the Rios, the BHPs and the FMGs on the mining expansion, and also trying to reach agreement on native title outcomes. So it was about as crazy as it could get. And as we were working with native title groups who were under pressure in relation to country and all sorts of things, we began to develop ways of thinking around what speaks to sustainability in terms of agreement making, and what skills I brought as a mediator and how we would build upon those to develop what we started to describe as collaborative conflict resolution. So bringing conflict up as something normal in human relationships and as the agent for social change, and very normal within traditional owner groups. And how can we find ways to have conversations with traditional owner groups that would form consensus and create sustainable agreements rather than creating division?
Perfect. So basically, Sarah, it's you and Michael. I'm just a spectator, however you want to take it. So.
Well, you're going to take over after I leave. But look, I wanted to set the scene for this conversation. And again, this is really about us as mediators and practitioners, highlighting that we want to keep this issue talking. What I think as an industry we're seeing is the recognition that caring for environment, caring for land is a matter of urgency, as is also a matter of productivity, and that as global warming and all of those complex layers are really big problems. And what do we do with these big problems? And there is a thirst for people for wanting to resolve it, to problem solve and coming together. And whereas I think in the past, these issues have been divisive, what I think we are seeing is a recognition that to fix these big problems, we all need to come together and work together. And that's where I see this role of mediators and mediation being really valuable to help us have really difficult conversations, really complex conversations with a lens on future focus, with a lens on perhaps not the ideal perfect outcome, but an outcome we can all live with. And that matters, right? Because we need to nurture this globe and we need to make sure that sustainability is there for our next generations. So I think that I want to encourage us as practitioners to start thinking about, what does sustainability mean? Instead of this operating from an assumption that we all know what that means, I think I want to say for practitioners, the first point of call is really to start with a conversation around what that means for the people that you're working with. Because it will mean something very different for a mining company, as it will mean for those from the environmentalist movement, as it will mean something really different for those people living on the ground. So I think when we start to unpack language, we create, I guess, a bit of a map about where those common grounds, common understandings are, but also where is the areas that we need to do work. I think that I'm seeing certainly an increased recognition globally of the role that mediation can play in bringing together issues like solar, wind farm, resource management, land management, caring for community, caring for culture, and caring for country. Both in Australia and internationally, right? We're starting to recognise the urgency of this matter. So sustainability, I think, is growing in a concept of what it used to mean. I think narrow, when people heard the word, they used to think environmentalism or global warming. And what I think we're seeing this trend is recognition that sustainability relates to land management and mining. It relates to a broad scope of environmental issues. And what role we play as practitioners is how do we facilitate a process that enables sustainable agreement making? And I think that is quite a unique offering we bring to this industry and this space, because if we aren't doing our job properly, parties will come out with agreement, but it's not going to be sustainable, which unravels all this hard work, which unravels the trust that we've tried to foster. Because I think what happens is, in this space, people feel deeply. They feel very strongly from a values-based perspective around what it means to care for the environment, about what it means to have wind farms in their backyard, and they'll probably feel very strongly in positive or negative. So we've got heightened emotions. And as practitioners, it takes a lot of effort to kind of capture that space and hold it in a way that people can talk about agreement making. And if we do that at a superficial level, if we don't think about the sustainable nature of the decision itself, then it unravels the trust that we've worked so hard to foster. So I'm really excited to have Michael here talking today. And Michael, when you step in, I'm hoping that you can share around some of those practical things that you've done and you've experienced around, how do you create sustainable agreements around these very big topics, right? Because they are big topics. And for those that haven't done this work but want to get into this work, I think it can be really daunting to know how to bring both my values and caring for the environment into complex commercial negotiations sometimes. And so I think that little things make a big difference. And so I'm really looking forward to this conversation, continuing Vikram onwards. And I'm really looking forward to some of the work, for instance, Mediators Beyond Borders International are doing around helping to bring mediation to the environmental space, the Geneva Convention and subcommittees. So we are seeing quite an upsurge in that. Miguel, who hasn't joined us yet, who may, I think it's very early over where he is. But for instance, the work that he's doing in wind farms and just pulling up his profile so I make sure I get this, offshore wind contracts, and recognizing that those complex sustainability and environmental industries bring with it a whole particular type of conflict that emerges. And so we have to understand that space that we're stepping into if we are to guide people through effective decision making. So I think that this challenge speaks to part of the issue around mediators finding their jam, their space, their niche of where they can really contribute and make a difference. And to do so, you need a really good understanding of those complex layers to guide people through decision making. Michael, does that resonate with some of your experiences?
Yeah, very much so. I mean, I think that it's going to be a really fascinating time moving forward. I mean, in terms of my point of view, or the view from the point that I've inhabited, it's been working for traditional owners, and sustainability for them has often been certainly understood in terms of their obligations to country, not that they own country, but that country owns them, and also their sustainability relationships to each other in law, LORE, and what that means, and how those sorts of relationships and law has kept them strong and sustainable, which they would say is then undermined by those proponents that have sought access to country. So it's always been a very difficult road to go as negotiating for traditional owners, where proponents are seeking access to country for mining, for example. This is a really interesting space because I'm also on the board of the Environment Centre in the NT, and it recently came up that this opportunities that we now have to mine for lithium, which we know is an important product as we move forward, in reducing global emissions, is going to necessarily involve an impact on country. We think it's necessary, but there's going to be a cost. When we're looking at solar wind farms, we know that that's a less impact on country, but then we're hearing that on not every occasion is it practical to use underground cables to get the power across to different parts of the world, but there's going to be need to convert to ammonia and hydrogen, which is still developing. So from a sustainability perspective, if I'm thinking from a traditional owner perspective, they're going to might be thinking, well, we didn't cause this damage to country, and now you want us to sort it out. And I just wonder how so I think as mediators, then the way that we enter that conversation is going to require a deft touch into where do we start? What's the place that we start in terms of having the conversation with traditional owners, so that they can begin the opportunity to talk about what does it mean for them? What does sustainability mean for them? What does the environment mean for them? What role do they feel that they're playing, given they still have, in many cases, obligations to country going back 40,000 years.
But what I would also, I mean, if people get time, I did one session on mediators, mediation, and climate change. So Kathy Porter gave a very nice presentation there. So please try and watch that. But on the sustainability part, I will also, on a general level, also would you be talking about sustainable agreements and sustainability of the process and what has come out of that in general, not relation to the depletion of natural resources as we understand it. Maybe if we can also look at that. And the other thing, of course, that came up from that discussion with Kathy also was getting all the stakeholders into it, and who are the stakeholders. And because if you have to make it sustainable, everyone should be part of the process. So if some experience on that, if you have, we can also talk about that.
I might just jump in quickly, Michael, only because I'll have to leave very soon. But they're really, really critical questions. And I know these questions are being explored, certainly with some of my colleagues in the US and Canada as well, who are working with Native Americans and the Indigenous people in Canada around how do we negotiate a sustainable agreement when these issues are so complex, when factionalism happens intra and in between the groups, not just between different parties as well. So sustainability of agreement making is really becoming quite an interesting issue for mediators, because unfortunately, due to a whole pile of reasons, some agreements that were reached are becoming meaningless. They don't hold the legitimacy that they perhaps could have. And like I was saying, it does undermine that work that's been done. So as mediators, we're having to grapple with how do we create and help the parties create an agreement that is long lasting. And I think from my own perspective, part of that for mediators is not just focusing on specific outputs or indicators, but it's building into the agreement. What do we do when things go wrong? And how do we deal with the problems when there's differences within our own group? So it adds a layer of proactiveness to an agreement that focuses not just on the outcomes, but on ongoing process, ongoing relationships. In a way, I think as mediators, we started the profession thinking that we'd reached a mediation agreement and somehow the process concluded. And what I think we're seeing in particularly complex cases is a recognition that the agreement reached through mediation is really just the beginning of the ongoing relationship. And so if we think of sustainability and the mediation agreement is just the beginnings of a relationship where it's required, where there'll be continuing interaction, it shifts then the types of questions we ask. It shifts then the type of inclusions we put into agreement making and the clauses we make sure we cover off, because we have a shared understanding that this agreement is just the beginning of an ongoing relationship. And that's particularly critical for issues when we're negotiating perhaps land rights use, when we're negotiating corporate contracts, when we're working with Indigenous peoples and companies, even interstate negotiations and corporations. I think this notion of sustainability is really around how do we give life to an agreement? How have we done everything to help this agreement have meaning beyond tomorrow? So I think that, that's my thoughts on that issue. Just quickly around shareholders, the stakeholders. It is a challenging thing in a multi-party dispute to be able to identify who the right stakeholders are to this agreement. Who are the decision makers that we need at the table? And that impacts on the legitimacy of any process that we manage. That's why I guess Michael and I are probably very similar in the preparation work that we do. It's knowing some of the right questions to ask. It's recognizing that somebody might have authority for this part of the conversation, but not for this part of the conversation. So we need to negotiate those elements. And it's bringing it to the surface and recognizing that there might be some changes as we go through. So it's alerting people to the need for flexibility. It's being able to ask the right questions. So if you go into an Aboriginal community, for instance, and say, who's got authority to make decisions on this issue? the assumption from a non-Indigenous perspective is that there is one person. And that's not necessarily the case, because there's a lot of nuance to it. And there's be different relationships. The Nganama and the Jungai have a responsibility to manage the country, but they don't have responsibility for decisions. So there's a distinction between roles and functions and authority. So they're the type of questions that it's so important you have an understanding of the context, of the culture that you're stepping into when we start to identify the right stakeholders.
And also, of course, we'll get Michael in. Before that, I mean, you want to leave. So I just want to ask you about any example of an agreement which was not sustainable. So we would be able to look at whatever the issues that came up, and maybe we can discuss that.
Yeah, look, from a non-sustainable agreement, so it's putting aside the environmental issues, but talk about from a community perspective, some of the work I've done. The unsustainable agreements that I've come across are ones where the mediator particularly hasn't understood the context within which they're going to operate. So they've come in with a set of biases and assumptions, thinking they have a little box around this conflict. And if we just talk about these issues, we'll have an agreement. But when you're dealing with complex, particularly community conflict, perhaps multi-party issues, you have to understand that what are the things that may impact on, one, the decision-making, and two, the capacity of people to implement this agreement in real life. And those considerations have to be part of process design and part of the conversation, because otherwise we set them up to fail. And so the mediations that I've had to come in and fix have been conducted by mediators who are well-intentioned and thought they were doing the right thing, but didn't really listen to the needs of the parties. They didn't really engage in a broader context understanding, and therefore they had a very narrow lens to the issue exploration.
Because also I think what we have to balance out is, of course, getting all the voices, but also the process should happen so that, because of course to hear everyone is a good thing, but the process has to move in a certain direction. So that balance, yes, getting everyone and getting the right people and who is the other right people, I think that aspect is also important.
It is, yes, certainly. And it is also, the reality is in process design, having a free-for-all and having everyone's voices in isn't necessarily the right thing. So can you do it in stages? Can you do it in little groups and then the big group? And Michael's certainly done some of that work around juggling multiple voices and allowing people to be heard. So on that happy note, Vikram, I have to wave goodbye to everyone and hand over to Michael's capable hands. And I hope you enjoy the continuation of this conversation.
Yes, it's a happy note for you. We are not very happy about it, but yes, you have to go. You have to go.
I know, and I owe Michael. Thank you, Michael, for stepping in for me.
So thank you, Sarah, and we'll see you, of course, in other sessions of the conference. So,
look forward to it. Take care. Bye.
So, Michael, you're going to be taking forward on this aspect that we were just discussing. So
yes, and I mean, look, there's just lots of ways we can take these sorts of conversations. I think it begins with that sense of, what are those sort of foundational skills that we have as mediators, which begin the conversations which move beyond positions, and all those useful fundamental skills. But then how do we allow ourselves as mediators the freedom, if you like, to then go, well, let's just take that and apply it in a context to different situations and around, providing opportunities, certainly from my experience, for traditional owners to feel as though they are equal partners in the process. So, as Sarah alluded to, and as a principal legal officer that I used to work for at the Gold Coast Land and Sea Council, said he came out from South Africa, and when he was working on the 4 big game parks, he said he knew who was the chief of that particular tribe and who he could speak to. But from my experience, the relationship with traditional owners is so nuanced and is so different across the country, and particularly as you move towards areas of desert, you're looking at areas where those that know the most say the least. Traditional owners have a history of having things done to them and having conversations started by non-Aboriginal people with the best of intentions that really start halfway up the ladder and they're not grounded. So it's an experience for me in terms of sustainability is where do you start to build rapport, and where do you start in terms of understanding the story? And those that I've seen start well has been to listen to what happens when you speak to Aboriginal people and you're negotiating, and they'll often come back to you invariably with a story about their history, about their country, about who they are. And it very much starts with that conversation. So I think for mediators, it's getting a sense of, well, when you're dealing with traditional owner groups, for them, a conversation starts in a different place and it's very circular. But if you want to look at building sustainable agreements, find that space where you can enter so that there's a sustainable relationship. And I think if you that can be successful in terms of proponents, people that want to go and access the country, giving more time, so creating a different sense of time and space around the conversations that are had with traditional owners, and providing them with the space to talk about what country means to them. What are their obligations to country? What does it mean in relation to protection of country and heritage, so that they feel as though that they are safe? Because I know from travelling through the desert that the traditional owners that were looking after some of the tracks that the tourists used to drive along were so concerned for the tourists driving along these tracks to be sure about what was going on, to understand where people were going, because they knew from a law and culture perspective that if somebody driving along the track came to grief, the traditional owner was responsible. So it's that sense of understanding how responsible the Aboriginal and First Nations people feel, what their law and culture says if there's damage to country. And that will always be, in my experience, that great challenge that we'll have as mediators where we're negotiating these types of agreements, to find a way to enable Aboriginal people to then be in a place where they themselves feel that they're being respected, so that they can find a balance between country they have to protect and country that they're prepared to allow access to for these important developments to take place.
Yeah. But Michael, you'll also, of course, that aspect of getting all the voices in, and of course, the process also should carry on, and getting the right voices in. That, how do you balance that, and some experiences that you've had and where you see the issues there?
Yeah, that's a really interesting question, because we know from working in native title that there are so many different types of relationships, and within an area of a claim there are different family groups, and within those relationships there's different families that speak for certain parts of the country, other elders that have certain obligations. And so for us as non-Aboriginal people, we're really in the dark, and we're really at the mercy of the groups. And we can go in and if we go into these open meetings of traditional owner groups, where I've been to, of about 300 to 500 people, you're really at risk of leaving the group feeling quite angry and upset about your disrespect or the way that you've actually participated. So, our experience in these types of things is to be able to begin respectfully through, their representative body, or the person that's looking after their interests, to start the conversation. But then to get a sense of, well, where do we start the conversation and where do we go to build up consensus? So in the work that I've been doing in Western Australia, look, there were working groups of 12. There were native title groups, sometimes of, as I say, anywhere between 100 to 500. But then what we needed to do was introduce another aspect to that, particularly when we were dealing with difficult questions around resolving native title claims where there were overlaps and these types of things, to sometimes get down to the family level. So what we found was, over a period of time, in our sort of collaborative conflict resolution model, was we had to build a consensus, a multi-party mediation, if you like, from the ground up. And that then required that we, in some cases, meet with the families. Because what we found was, in some cases, and it's quite an investment of time and resources, was that by meeting with the individual families, you're providing an opportunity for them to speak where they're not being shamed or shaming, that they're able to speak more openly about the pros and cons of what's before them, and then understand what unfortunately in some cases the legal system was requiring of them, what were their options, what weren't their options. And then with that information, and sometimes not surprisingly, they could be quite upset and emotional and angry about these things because they were in often disadvantageous situations because of the strength of the law and what it meant in terms of access to country, or what it meant in terms of the way the law was trying to resolve their claims. But at least providing that space where they weren't being shamed or weren't shaming, that they could get an understanding of and be in a better position to reach an informed decision. And as then you move towards a larger working group and the native title group to ultimately hopefully get to a place of free, prior, informed consent. Because certainly in my experience, the last thing you want to do is to go to a large claim group without a pretty good sense of how the group's going to go with the resolutions you put forward. Because despite what we think, or may not think with First Nations people, they're very cautious and very conservative in relation to how they deal with country. And so they don't want to be rushed. They have a different sense of time and space before they feel comfortable to make a decision. And I think that's one of the things that we learn through difficult and sometimes bitter experience to provide better time and space.
Yeah. Only thing, I'll just get Emma in, I'll introduce her, but I'll just tell you there's a symposium that's coming up, which is starting on 9th August on Indigenous peoples and mediation. So you have to be part of that, Michael. We'll fix the time according to your convenience. So Emma, you want to meet Michael? Michael, Emma.
Hi, Emma.
Nice to meet you, Michael.
It's a pleasure.
So I'm just trying to catch up, but I get the sense that you're talking about kind of large scale multi-party mediation with Indigenous folks in Australia.
Yeah. Correct. Yeah. So for me, the experience came out of the mining boom in the Pilbara between 2007 to 2012. I mean, it was already happening in Western Australia, but certainly things went gangbusters then. And so we had the companies like the Rios and the BHPs and the FMGs seeking to double the railway lines and up production to meet the demand in China. And there was a voracious appetite to get access to country. And we, under the regime in Australia, under the Future Act process, at the end of the day, they were going to get access to country generally. But we knew that for those mining companies, the notion of social license was so very important. So there was no point in just winning the battle, and from a legal perspective, that social license internationally was critical. So it meant that there was a preparedness to negotiate on an extended basis to reach agreement on these agreements, which we did. But in terms of sustainability, ongoing issues to this very day with those agreements. And there's examples that we've heard, in the news around sacred sites that were damaged. Issues that have remained, and whether that commitment to having that ongoing dialogue and that relationship that was built into the agreements was maintained. A very difficult thing to do when mining companies can evolve and the economy changes and circumstances changes and different management comes into these companies with a different emphasis.
But I think also the thing is that there's been some discussion on my shows. There's Luis Ore, who's in Peru, Ivan, who's also in Peru. They've done some very interesting work with mining projects. So of course, you can have a look at that also. Those sessions are there. You can just search, like I said, on YouTube, Mediator Vikram and Luis Ore. So that's interesting. So because I'll tell you one thing that I'll really be interested in, the next generation coming in, how does that change the agreement and the sustainability of agreements? If there's something on that experience that you had.
The next generation of First Nations people.
Yeah.
Yeah. Look, that's a whole new question in itself, isn't it? In some parts of the country, at the moment, I'm in the Northern Territory, and my daughter's just come off working on a community in Northern Arnhem Land where the Yolngu people live, and there's a sense of that culture that it's had a rare opportunity really to continue to develop and maintain strength around law and culture fundamentally. Even so, things have been lost and won't be regained. I think things will be lost forever. But certainly as a culture, that's an example that I've observed that's quite strong and has been handed down. Throughout other parts of Australia, which I'm sure has happened in other parts of the world, there are different groups that are certainly impacted by European colonisation And we were already back in, the early 2000s dealing with groups where, that had an impact upon their understanding of culture. And so that made it difficult for them to be clear about their own position, which was very difficult. In other cases, for groups that were still very traditional, and this is something that you come across as you get to know the traditional owners, understandably, many different opinions about these types of things, even amongst people that were, had good knowledge of country. Some that felt that country could look after itself and that there was an opportunity to be able to negotiate agreements because they wanted to step out of the poverty culture, and others that said under no circumstances could country be impacted upon. And so with those sorts of questions already in place, the next generation, I think, will be more savvy in some respects, but also more at mercy in terms of perhaps challenges around knowledge of country, and also uncertainty about how to protect country, and also concerns about what happens if they're not protecting country.
Well, I'm just looking for the perspective that do their needs change? If the needs of the community change or the structure of the community changes, all those things that you have been the foundation of that agreement might change. So how, because if it has to be taken forward, of course the next generation has to take it forward. So what comes up in between, if there's been some experience, I mean, of course you've spoken about some things, but on that broad kind of a thing, I'm just looking at it because definitely those communities are changing. It's not that they're not influenced by what is happening around the world. So I don't know if you have some thoughts on that.
Well, I mean, it's interesting because working in this organisation at Relationships Australia Northern Territory in Darwin, and we have an Indigenous group of staff. And one of the ways that we've tackled their relationships to each other as Aboriginal people, and then their part in an organisation is to come up with a sense of dual sovereignty within our own organisation. So we talk about it in terms of the circle of traditional obligations under law and culture, and the square being a non-Aboriginal corporation, and how they can participate, having respect as elders, but also understanding that if they want to step into the non-Aboriginal world and become a manager, there's going to be all those obligations that managers invariably have, and is that a space that they want to occupy? So I say that simply because from my perspective, this notion of the two worlds learning that we describe it is critical. And so what I'm seeing with non-Aboriginal people and the next generation is this notion of two worlds. They're becoming more adept at that. I think all of us understand that is the world that they're invariably going to live in. It does require obligations on their behalf. In terms of what they want, Vikram, to be honest, it would depend. It would depend upon the location of the groups, whether there's access to sometimes business opportunities, which is very difficult, remote opportunities, whether certain groups are looking for education opportunities. Other groups in other parts of Arnhem Land have a greater connection to arts and crafts. So to generalise it would be to not do justice to just the individual nature of where groups are sitting and what aspirations First Nations people are having, which is developing and growing as they become more, as they learn to live more adeptly in two worlds.
I'll just get you in 1 minute. The one thing that I just want, the situation in Peru is that the community owns the surface and the government owns everything below. So the community has to be taken into account whenever there is the mining project which comes up. How does it work in Australia?
That's fundamentally the case under the Mining Act. The only comment I'd make about that is that from a traditional owner perspective, it's the country that owns the people. And that's where their obligations sit. But certainly in terms of native title, for groups that are granted native title, there are those traditional native title rights that are recognised. But fundamentally, as we know, going right back to Mabo, when the High Court made that landmark decision around that recognition of native title, they themselves were part of a sovereign nation, so they weren't challenging the sovereign nation. And so it's always the case that as a native title holder, you're still always subjected to non-native title rights. So at the end of the day, when a non-native title party under the Mining Act wants to gain access to country to do mining operations, fundamentally the law will support them to do that. And at the end of the day, native title holders in Australia under the Native Title Act, at the end of the day, have a right to sit at the table. They don't have a right of veto in relation to mining operations. It's different in the Northern Territory under the Land Rights Act, because they do have an initial right of veto. But if they give up that right of veto, then they let the proponents in the door. The interesting thing about these future-focused agreements around solar and wind production is that they're a little bit novel. They're not set out in the Mining Act. There's different legislation in Australia under the Land Administration Act. So it puts the native title holders in a slightly stronger position, and it will provide a better opportunity for them to be at a slightly better bargaining position, which as a mediator we need to be thinking of, because we're dealing with parties to a negotiation that don't have equal, bargaining power. They're at different places in terms of where they sit in terms of what the law does. But certainly in terms of these projects, from what I'm hearing and the people that I've spoken to, proponents are approaching it from a different perspective to a way that's traditionally happened, certainly Western Australia and other parts of Australia around mining.
So Emma, basically, of course, Michael comes from that experience working in Indigenous people, but from your side, anything, we're talking about sustainability and mediation. So, of course, sustainability of agreements, and to have sustainable agreements, what all needs to be looked at. One, of course, we were discussing who are the stakeholders, bringing in the stakeholders. So one part was that within the stakeholders, of course, there are groups there. So how do you handle that? Then on the aspect of you want to hear all the voices, but you still want the process to go through. So get the right voices. How does that work? So these were the kind of broad things we were talking about. So anything that you would want to bring in there?
Just listening to you there, Michael, I was wondering how the system in Australia compares to the system in New Zealand. Do you have any experience of how New Zealanders handle similar circumstances?
Look, not a great deal of experience. I mean, we know that the whole way that non-Europeans settled New Zealand and that notions around treaty has produced results which were not honoured by European civilization, but over time, I think the Maori culture has pulled it back. I mean, my experience, and I don't know if this answers your question, Emma, of going to New Zealand, and my wife has a Maori heritage, so it's an interesting space to go back to, is that in New Zealand there's one language, and there's a sense when you're there in New Zealand that it's a much stronger honoured culture. What I've observed anecdotally and from people from New Zealand that have come out to work in native title, Maori people, is that there is a certainly stronger recognition of the cultural strength of Maori people, and you see it in sort of ways which maybe tabletop discussions, coffee tabletop discussions, but even in things like the haka, there's a way of recognition as a nation of what the strength of the Maori culture is. The challenge in Australia, if you look at the map of Tyndale, is that there's hundreds of nations forming the traditional owner fabric throughout Australia, and that relationship that you might have is so nuanced. And as I was saying earlier, those that know the most say the least. So when I was working in the goldfields and getting involved in working with various groups and going out to meetings, it was after 2 years of being there that finally some of the elders came up and said, "Oh, we're going to have a chat to you now." So the notions around time and space are so different that invariably as non-Aboriginal people, we're not aware of it, we're not listening to it, we may be impatient about it, and so we find ourselves jarring with their sense of time and space and relationship, and that can undermine sustainability and agreement making.
But
Yeah.
interesting.
2 years, that's a long time to be on the balcony, isn't it?
Long time to be 2 years.
But yeah, that's interesting.
But Michael, the interesting thing that came out, there was a symposium that I did last year, and I like to talk about it because someone had called it the Woodstock of mediation, because there were 97 speakers from 45 countries. So in that, we had someone from New Zealand. So there is a word in the Maori language, which is what we use in our language, in Hindi. which I found really interesting. That a word that they use for the same meaning. I mean, the same meaning of the word that we have. So I found that connection really interesting. Where did that connection come from? And this is when they're talking about the Maoris landing up there. So there was some word that was man was a word used there. So that's something which I found really interesting. Maybe we could look at language as a separate aspect of connecting people, but not in relation to mediation, maybe. But Emma they've come out with a green pledge, and we're going to be talking about that in the next session, Michael. So please stay for the next session. Of course, the next session is also about mediators, mediation, and climate change, because we had one discussion on it. The issue is that those discussions, a lot of discussions happen in the evening, and Australia gets left out of that. And that's where a lot of people from Australia have not been part of my discussions. So, and of course, Sarah is not, she's only 2.5 hours ahead of us. Of course, Sydney becomes 5.5 hours. So for them, it becomes a little late. So that's why we're doing it in the morning also. So please, in that also, you can bring in your thoughts, mediators, mediation, and climate change, of course, broad topic. But on the sustainability part, Emma, you can look at it. I mean, of course, we were talking about multi-party mediations, but anything else that you want to bring in terms of sustainability, of course, as we understand in terms of natural resources and that aspect of mediation, but also sustainability of agreements of mediation, what comes into play in that. So any thoughts? We're just bringing out thoughts. That's it. Nothing else.
Well, I mean, what I'd be happy to share, I don't know if it's quite what you're hoping I'll share, but I had the privilege of, in fact, I think you, Vikram, you might have been there. The Mediators Green Pledge held an event around COP26, Michael, and we were really delighted that William Ury spoke at that event. Wow. And he spoke about something that I certainly hadn't heard of, which was the Climate Parliament.
Right.
And 80 countries around the world have signed up to committing to the green grid. So that is based on the notion that the sun is always shining somewhere, the wind is always blowing somewhere. Certainly in Scotland, the rain is often falling from the sky, as it is as I speak to you this morning. And so is there a way we can harness the natural resources available to us in a way that allows us to distribute it around the world? And William Ury's perspective is, who is best placed to have these conversations about these big issues? Is it the politicians? Is it individual governments? Is it government interconnected organizations? I mean, yes, it is all of those, but what our experience shows us is that it takes them a long time to get anything done. And we don't have time. We're running out of time. So he is asking the question, if not mediators to have these kind of conversations and enable these multi-party conversations, then who? And in fact, what I didn't know is that at COP26, which is something that certainly didn't get, as far as I could tell, any press coverage in the UK. I don't know about around the world, but Prime Minister Modi was announcing that he was signing the One Sun Declaration, and this was related to the green grid. And 80 countries apparently around the world have committed to doing whatever they can to work towards one sun, one world, one energy source. So William Ury was really inspiring at that event, because he's saying, come on guys, you're mediators, you've signed the Mediators Green Pledge. It was obviously a self-selecting audience, but we have a contribution to make here. And so what's stopping you? And he has obviously various ways and ideas of ways to include others in his drive to do what he can to change the conversation, move the conversation on.
It's fascinating. Look, mediators, by virtue of the training that we get, are extremely well placed to begin that conversation because of the way that we choose to enter a conversation. I suppose the thing that I'm finding really fascinating about all what's going on is, without wanting to get political, we've had a change of government in Australia, and there's a different view around, reducing greenhouse emissions that many of us are very pleased about. And there's also a notion now about constitutional recognition for the First Nations people, which is something that's been hanging around for some time. So there's a document here called the Uluru Statement from the Heart that we want to bring to the fore. And I say that because with what's being spoken about now within Australia and around the world about this push towards, global emission reduction, which is such an important thing, we need to be having conversations with First Nations people here pretty quickly about this, because as always, they feel as though they're the last to know. I'm sure they're getting a sense of what's going on, but I'm aware of projects that have been spoken about, within Australia, which are, very large projects, setting aside huge areas of land for solar wind farms and for potentially ammonia and hydrogen production. And the traditional owners are going to need to be listened to and understood about where do they sit with this? Because at one sense for them, it's about protection of country. And so there can be potentially advantages in terms of maybe agreeing to a solar wind farm because there's less damage to country, but then country's also locked up for many years. So I think I'm not yet hearing a voice, and it's never one voice, but I'm still waiting to see where the First Nation people are coming out in this, in relation to their sense of joining, the world in a problem that we've created, when traditional owners might say, we knew how to look after country. Unfortunately, you didn't listen. And now you want us to sort out the mess.
But Emma, you do know that you'll have to repeat this whole climate parliament in the next session, all that aspect of it.
Well, I wasn't necessarily going to talk about that, but I'd be happy to.
The other thing, let me tell you that basically Ken Cloke has written about the role of mediators. So what you could do is you could go to my website. There is a special section on celebrating Ken Cloke. So you can go there, and then in that there is that link to the article that he wrote about the role of mediators in global problem solving in relation to climate change he was talking. So you can click here and read this article, because obviously he has looked at the larger role of mediators, and of course them being part of these discussions like COP26 and all that. Yeah. So the only thing I keep telling him also is the fact that please, we have to create an environment that mediators can practice as mediators full time. They should be remunerated well. This whole free thing has to be removed. Then we can talk about the larger role for them. Right now, for them, that whole concept of even practicing as full-time mediators is not happening. So that, I mean, I'm not going to that direction. That's a whole discussion that I keep having, and of course in the conference also we have been discussing, and we will discuss that. So I'm just putting that across to you.
Another thought, I suppose, was, and I appreciate you may well have covered this already, but whether there's a framework that actually builds in the involvement of mediators in your discussions, Michael, or whether that's something that you're trying to do as an outsider, as it were.
Yeah, so for us, as trained as a lawyer, moving to mediation, working with anthropologists, getting into native title, and understanding the complexity of relationship, we developed our own language around this in terms of collaborative conflict resolution. So we thought that there was, starting with mediation skills, but building on that to sort of to build a way of getting into the story that had a sense of being able to hold the rich fabric of the story. And for us, it would then be different conversations depending upon different groups. And it was a really place-based discussion often about, well, this particular group, we need to start with the family. This particular group, we need to start there. This particular group, we've got this particular, this elder is feeling disrespected. This person has confusion in relation to their culture. They believe they're part of this group that was not. So how do we deal with those sorts of issues? So I think if we were talking sustainability, in an effort to get into that space, so that at the end of the day, because as non-Aboriginal people, we've got a purpose. We want to settle the claim. We want to get an agreement. It was a way of respecting often issues of identity, because it was all around identity, and how we could let people be heard to express what we talk about as mediators in terms of interests, fears and concerns. But for traditional owners, their connection to country, their obligations to country and to family, And we found that as we found ways of doing that, that and that involved a much different sense of time and space than we would normally provide, they could, once all that had been aired, they could sit there and go, oh, all right, now, maybe I can. I mean, I'm prepared to listen to what your white fella's got to say. Mm-hmm. But we have to let them do that first.
And Michael, who's inviting you into that conversation, or are you inviting yourself?
We carefully find our way in. Certainly,
again,
we do carefully find our way into the conversation. Okay. For us, the keys to the kingdom were often with the Aboriginal advisors that were working for us. So they had relationships with traditional owners, and they could take us to meet with people. But also, we had anthropologists and archaeologists that, for many years had developed relationships, with traditional owners, and indeed many lawyers had, where we were able to start a conversation, and we had a sense of where should that conversation begin, and with whom, and around what country, and let it sort of go from there.
Mm-hmm. But Emma, I'm still asking you, anything else that comes to your mind? We've gone into this direction because Sarah had suggested the topic, and this is what we were talking about. But okay, putting all this aside, if there's anything else that comes to your mind in relation to sustainability and mediation, please tell us.
Oh, well, lots. I suppose I would start, Michael, I'm also a lawyer, and I'm very struck by how sustainable a dispute resolution mechanism mediation is in comparison to litigation, and even in comparison to arbitration. And I know that there are, so the Mediators Green Pledge that I'm involved in was inspired by the Arbitrators Green Pledge. And Lucy Greenwood, who really was the kind of, had the brainchild, I think, in the first place, has actually measured the carbon cost of arbitrations, just in order to have some kind of starting point to say, guys, this is not sustainable. And that was pre-pandemic. So it's been interesting to see how the pandemic has encouraged people to think more creatively about, the logistics of arbitrations and so on. But I think we're here to talk about mediation, and my view is that mediation is infinitely more sustainable than even arbitration. And that actually, if countries want to think about net zero and a net zero civil justice system, mediation has to be at the heart of that.
I couldn't agree more. It's a way to begin a conversation, which certainly, when you're talking about these types of complex issues, provides the only opportunity really for people to start to, really deal with those sorts of issues, which, if not dealt with, undermine sustainability. So completely. And I suppose my experience for me is, having been as a lawyer starting in the 80s and working in crime, and then finding the joy of mediation in the 90s and thinking this is a much better way to practice, and then getting into native title in 2004 is to say to the mediators, this is a great place to start, but it's only the beginning, because with some of those fundamentals, we took it to different levels. And so, for example, with groups, there's the talking circles that we would have with traditional owners. And I can remember as mediators and with a peace builder out of Northern Ireland, we come up with ways of developing open conversations with traditional owners in a circle. And it was a way of enabling people to express fundamentally interest, fears and concerns. And as we set up this talking circle, one traditional owner said, "What are you doing? This is what we've been doing for thousands of years. You're just stealing our business." So there was a universal nature to this, which was quite remarkable, and it was really encouraging.
Well, that's right. I mean, you think about the Native Americans. I mean, they were mediating, right from the get-go. That's how they resolved their conflict. I mean, we know this is not a new idea, but it's remarkable, isn't it? How in our modern world it's just not used. And well,
what I'm going to do is
we're all in agreement.
What I'm going to be doing here is, we'll cut this session, we'll start the next session, only because social media, if you don't start that session on time, thinks that you've cancelled the event. So I'll just start that. So of course, in this session, Thank you, Michael. We'll, of course, welcome you in the next session also. Thank you very much, Emma, for coming in. And of course, Emma, I did not tell you, I don't use the A word on my shows. That's a banned word, but you've used it, but it's actually banned. Arbitration is not to be used here.
Okay.
So thank you very much.
Respectful of our colleagues in the world of arbitration.
Yeah, but I'm going to start that session and we'll talk about